But all said and done, ultimately what boils down to is the audit, because generally organizations are more worried about conducting those audits, the results. So if they have to go through these audits, what should be a audit package really include, and especially to begin with the internal ones. So to start with, I think we'll stick to that right now, at least the internal reviews while happening the audit, what audit package should include.
I think so. Let me start from where I left off. So when we talked about non-negotiable policies, the audit checklist has to first have that in place.
Right.
So the audit checklist should see that whether the policies are in place, when were they last updated, how have they been implemented, uh, were there any gaps that were discovered in the last audit, when was the last audit done, were the gaps plugged in by the time the next audit, or are the gaps just continuing year after year? Is anybody even looking at those gaps, and is anybody trying to sort of to cover them or to bridge those gaps? So that would form a very important part of that audit checklist. I also stopped where I said there has to be an incident management policy. So in
Correct.
an audit, the moment we talk about that policy, even in the audit checklist, that has to become part of the audit, that what have been the incidences in the past, that auditable period, how has the company responded to the incidents, what were the learnings from that incident, and what does the company look at while trying to build on either that policy or the process that has been there. The audit also needs to have the functions or the roles of the people in charge of privacy audited, that whether the functions have been adequate, whether the roles have been adequate, is there any overlap in the roles, were any confusion created between IT and legal while dealing with a certain maybe situation, how was the DPO able to resolve that? That will also form a part of an, if I can say, an internal checklist. Also, the data protection impact assessments are a very crucial part. That how many times it has been conducted, what has been the outcomes, have we learned from the outcomes of the DPIs, what has been the maybe the term at which we do it, or the frequency at which the impact assessments are done, what functions participate in the impact assessments. You can also see whether any functions of the businesses are not cooperating in it.
Okay. Right.
Then I think one more point that I can think of is audit about the access rights of data principals. So
Right.
how many people asked for their data to be updated? Uh, mm, uh, were we able to answer that request properly? Was that answer given on time? Were our systems ready for that kind of a request being handled? I think those are at least a few things that form part of the audit
Yeah,
checklist.
I think many of those that you have covered, and I don't know, I'm sure a lot of them would have made a note of those checklist, and they would have got something to take away with them in terms of the checklist which can be added, and we can always share, more inputs if they have, because we may have some questions, we can take up that also, and then clarify more in terms of what else or what more we can look at. So while we talk about this is all about the preparedness. It's about keeping the checklist, having the audit done internally, and maybe later there's something, external audit is done. But what if something goes wrong, right? Because that's the fear that will always be there, that what if something goes wrong? How should we be prepared? What are the penalties? Because there's a huge, amount of penalty, which is, at least when we talk about DPDP Act, yes, there's a huge amount of penalty which is involved into this. So while organizations are getting prepared for enforcement of the regulatory requirement around DPDP Act, they would obviously want to be ready in terms of, though we talked about checklists, but I still feel that I hope this question doesn't sound repetitive, but if there's something differentiating which you think you can specify about the documentation trail, which should companies maintain in order to defend themselves in case there's something which has gone wrong or something which is highlighted, which will help them. So
So,
what could be that?
yeah, so Isha, if you see, the law is not prescriptive at all. The law just talks of principles of data privacy. The law talks about why privacy is important for an individual and how should the companies ensure that the rights of the data fiduciaries are protected. Now, it's a good thing or a bad thing. Good thing, why? Because it gives you a lot of freedom to do to to achieve that result. You can be creative, you can be flexible, you can have your own way of doing it, as long as you are able to demonstrate that you have done XYZ to achieve the certain objective of the DPDP Act. For example, data retention. So, does the law say that you have to retain the data for X number of years? You have to delete the data in a certain manner after X number of years? No, it doesn't say any of that. It just says that you need to, an organization needs to finally decide how their data retention policy is and then adhere to it. So, I love this flexibility. It really gives you a free hand to do what is expected out of you in order to achieve that objective of privacy. Now, having said that, let us also look at what the Data Protection Board would do. What would you and me do if we were on the Data Protection Board? Let's ask ourselves this question, that if you were part of the Data Protection Board, how will you go after companies? What would be your mindset? And I think my mindset would be that we've just started, so let us not look after, go behind the companies and say, what is it that I can do so I can slap 100 crore penalty. Rather, I would say, even as a board, I would say, let me see whether they have got their basics right, isn't it? So
Yeah, yeah,
the,
absolutely.
the question is now on us that let's get our basics right. So do we have the consent mechanism in place? Have we really understood how to obtain consent? Is the consent unambiguous, free, without coercion, and all the principles around consent? How is our notice worded? Does it serve the purpose? Do we have a data protection officer appointed? Have we ensured that there is no conflict of interest? Do we have a grievance officer appointed? Are the terms and conditions which are published for the data fiduciary to consume easy to understand?
Right.
Are we ready to report a breach incident? So these would be the basic expectations a data protection board will have from you. And basic readiness is, I feel let's not do everything at once. We are maturing now towards compliance on data. We have just started, and
Right.
there will be stages. This conversation we will not be able to have after 5 years. A company will not say after 5 years that, oh, we are still sort of, discovering. I'll give
Absolutely.
you another, a parallel example how it happens in courts. When our juniors or my junior colleagues go in before the judge, and sometimes they're not prepared, a little anxious, and I tell them this is the best time to be, because you can actually tell the judge that I want to argue this case. Today I'm not prepared. Just give me a short date and I will come back. and the judge will listen to you because he also wants to give you an opportunity to develop you as a lawyer. But
Okay.
if I go and say, no, I need time, he's not going to listen to me. He will say, what were you doing for 25 years? That you are not ready even today.
Okay. Yeah,
You know,
absolutely.
same applies.
Absolutely.